morning, everyone. Thank you for joining us today at our webinar, The Ultimate Employer's Guide to Employers' Contracts. Today's webinar is brought to you by Peninsula Island. As a trusted partner to over 6,000 Irish businesses, Peninsula Island keeps small businesses compliant with award-winning HR consultant and health and safety outsourcing. Today we are joined by my colleague Lesley. Lesley is a HR consultant here at Peninsula. There has been a whole host of employment law changes this year, last year, and it's becoming a real challenge for business owners to stay on top of their obligations to employers. We're delighted to have Lesley here today to go through these slides with us. She's a wealth of knowledge here at Peninsula, so we're delighted to have her. Lesley, if you're ready, I will hand over to you.
Thanks a million, Sarah, for that introduction. Okay, guys, so I'm just going to go through basically the legislation updates and the contract requirements today. Today's webinar is brought to you by Peninsula Ireland, a trusted partner to over 6,000 Irish businesses, and Peninsula Ireland keeps small businesses compliant with award-winning HR consultancy and health and safety outsourcing. So for today's agenda, we have the essential elements of your employment contracts and policies. We're going to go through your employment law legislation changes, and then we will have a question and answer section at the very end. I know you guys have submitted your pre-prepared questions, and I have pre-prepared answers for those at the end. We'll try and get through as many as we can. Okay, so the first section we'll go through is the contracts of employment. The most important question: what is a contract of employment? So a contract of employment is an agreement between an employer and an employee that stipulates the terms and conditions of employment. So basically it's a legal agreement that there's a clear intention that should one party fail to keep any of their promises, the other party may take an enforcement action for breach of contract. A contract of employment will comprise all of the terms which the employer and the employee have agreed for the purposes of the employee's employment. So for example, if the employee was offered 20 hours per week on their contract and the employer only provided them with 15 hours per week, then that would be a breach of their contract. So what are the legalities of a contract of employment? We have statutory terms, implied terms such as custom and practice, express contractual terms, and incorporated terms. So we often call a statement of main terms the contract of employment, but technically this is not the correct label for it. The statement of main terms is a piece of paper that the law requires you to give to the employees as part of the contract of employment. On top of the statement of main terms that we create for you, it will say that this makes up part of the contract of employment, along with the employee handbook. The contract of employment is not a tangible item, and it includes all terms agreed with the employee, as well as some not expressly agreed. Your statutory terms, so basically this is the terms of employment under the Information Act 1994 to 2001. This states that there should be all the requirements held within the employee's written statement of main terms and conditions, and these can range from: you'll have the full names of the employer and the employee, you'll have the address or registered office of the employer in the state, you'll have the title of the job and the date of commencement of the employee's contract of employment. You'll also have the rate or the calculation of the employee's remuneration and the rate of pay for the pay reference period. You'll have any terms or conditions relating to the hours of work, including any overtime hours. You'll also have any terms and conditions relating to paid leave other than the paid sick leave, and you'll have pensions and pension schemes included. Finally, you can also have the notice of employment which the employees must give to the employer and also which the employees are entitled to receive. So moving on to the implied terms. The implied terms are not written or spoken but still govern the employment relationship. So for example, if you have been giving the employees 25 days off for their annual leave, all of the time that they have been employed with your business, you cannot simply switch back to giving them the statutory annual leave, which is 20 days. And express contractual terms, so these are clearly stated either in writing or orally. They are terms, comments, and agreements made, potentially even made at the interview stage. And then finally, your incorporated terms. These are brought into the contract through the handbooks, policies, etc. So your statement of main terms and conditions. Under the Employment Miscellaneous Provisions Act, you must provide your staff with 5 key terms of employment in writing within 5 days of their start date. So the 5-day statement, core terms of employment. This includes the employer's name and employee's name, you have the employer's address, you have the duration of contract, the rate or method of pay, and the normal length of the working day. So this was the arrangement prior to the EU Directive of Transparent and Predictable Working Conditions, which brings me to our first poll. Have you heard about the changes from the EU Directive on Transparent and Predictable Working Conditions? I'm sorry, I'm just trying to open the poll answers here for you now. I don't seem to be able to see them, Sarah, if you have them.
Yeah, no worries. It's just they're just counting them now, so be 1 second.
No problem.
Okay, cool. So the poll answers have come in. I'm not sure if you can see these, Lesley. So we have 35% who have said that they have heard about the new EU directive, and 65% of the people have not heard of it so far.
Okay, great. Thanks for that, Sarah. Okay, so we had 65% who hadn't heard about the EU directive. And what that means is we now have updates to the core terms of employment that we must issue within the first 5 days. You can see here the additions are in red. So along with the original terms and conditions that we just discussed, we now have to include the probationary period, the job description, the date of commencement, the terms and conditions related to the hours of working, and also the place of work. So all employees are entitled to receive all these core terms and conditions within the first 5 days of employment. After they've received the first 5 core terms, you have 4 weeks to issue them with their full entire statement of main terms and conditions. So prior to this EU directive, you would have had 8 weeks to issue this document, but now you have 4 weeks to issue their document. So their full contract of employment, you must issue that within 4 weeks of their start date. Okay, so changes to the legislation. What changes have we experienced in the legislation to date? As we've just mentioned, the Transparent and Predictable Working Conditions 2022. This is a directive that aims to provide more security to employees in precarious forms of employment, like employees on temporary contracts or gig employment workers. The regulations introduce a number of new pro-employee rights under the following statutes, and it's under the Terms of Employment Act 1994, the Organisation of Working Time Act 1997, Protection of Employees and Including Fixed Term Work Act 2003, and the Workplace Relations Act 2015. The Work-Life Balance and Miscellaneous Provisions Act, it introduces 5 days of unpaid leave for medical care purposes for parents of children under 12 and carers, and also paid leave for victims of domestic violence. It also introduces the right to request flexible working for parents and carers, right to request remote working for all employees, and it's also introduced breastfeeding breaks, which are extended now to 2 years. So the future legislation will also incorporate the previous right to request remote working bill that was introduced in 2022. The bill will give effect to the EU Work-Life Balance Directive, introducing a range of measures to improve family-friendly work practices and support women in the workforce. The proposed legislation will give parents and carers of children under 12 the right to request flexible working, and it will introduce 5 days of unpaid leave for medical care purposes and extend the entitlement for breastfeeding breaks from 6 months to 2 years. The bill will also see the introduction of paid leave for victims of domestic violence. So we have got the breastfeeding leave already introduced, that's in currently. The unpaid leave for medical care purposes, that's also been introduced. The domestic violence leave, that is expected to come in hopefully at the end of the summer. And then the right to request flexible working for the purpose of caring for family members, also the right to request remote working, that is expected to be introduced by hopefully the end of autumn. That brings us to our second poll. Do you currently have remote workers? So I think we're just gathering up the results of the second poll now. I think, Sarah, you'll have to call out the results again. I don't see the poll results here, unfortunately.
No problem, I'll bring them up in a wee second. So again, it's looking like a similar breakdown. So we've got 65% who have remote workers currently, and we have 35% who don't have remote workers.
Okay, so kind of nearly 50-50 split. So right, so just a note on that before we move on to the next piece of legislation. If you don't have any remote workers or hybrid or flexible working options already in existence in the business, and you want to prepare in advance of the legislation coming in, I think now is probably the best time to look at your internal company policies. Make sure you have determined what you can facilitate, what you can't facilitate, and what it would look like for your business if you were to have these flexible working requests come in, just so that you're prepared in advance to preempt any requests as they start to come in, because they will inevitably start. So the next one is the Sick Leave Act. I think probably everyone is familiar with this act at the moment. It was introduced at the beginning of the year, but just in case anyone was not familiar with it, I will go over with it again. So basically it provides all employees with the right to receive statutory sick pay from the first day of absence due to an illness or an injury. It entitles employees to 3 days paid sick day per year this year. It will rise to 5 days in 2024, 7 days in 2025, until it reaches a maximum of 10 days in 2026. For entitlement for this act, the employees must have 13 weeks of continuous service with the business, and they are paid only a 70% rate, so it's not 100%, it's a 70% rate of their pay. And if it's the case that they're on a higher earning salary, well, the maximum rate per day is €110. So you can cap it at €110 per day. It does require medical certificates, so if the employee fails to submit a medical certificate for their absence, you do not need to provide them with sick pay leave. If they do provide you with their medical cert, then obviously you will provide them with their entitled pay. This is also a good opportunity to update your absenteeism policy, ensure that you have the correct policy in place that identifies to your staff who they need to contact when they're sick, when they need to contact. If it's a case that you want to contact at least a minimum an hour before they're due to start, is it a direct phone call to their manager? Do you accept text messages or WhatsApp? So it's very important that you have highlighted your absenteeism policy for your staff, and that's been made available for every employee in the business. So we have another poll, and the next poll is, do you currently pay sick leave to your employees? I think I'll have Sarah go through all the polls because for some reason they're not coming up for me. Let Sarah build up the answers.
No worries, Lesley. I'll just wait a couple more seconds here while we get the last of the answers.
No problem.
Okay, so currently 48% of the attendees are paying sick leave to their employees, 20% are not, and 32% are providing sick leave pay when a sick note is provided.
Perfect. Okay, thanks for that, Sarah. So for the 20% that are currently not paying any sick pay, it's very important that this is introduced because it is a statutory entitlement now. So a statutory entitlement means the employees are entitled to this pay. It's not a recommendation, it's a requirement. So we do have to enforce this into all our businesses. They will follow the same pattern as mentioned above. So for this year, they're only entitled to 3 days of pay. Okay, so the next section we'll go through here is, do I need an employee handbook? So an employee handbook, this is the question we tend to get asked very often. Do I need an employee handbook? And the short answer is yes. It's very important to have an employee handbook in place. An employee handbook is a great way of making sure that employees have access to the information you need them to know about, like policies, procedures, and while keeping the information in their statement of main terms separate. So basically, it's your way of ensuring your staff are aware of what the rules and regulations are within the business, what the policies and procedures are, and it's important that it's given to the employees in writing so that they're aware exactly what is expected of them. You'll have things like capability, performance, attendance, conduct, whether it's a major, minor, gross misconduct. You'll also have stated there in the handbook what could be expected as an outcome if there was such a conduct to arise. So are they going to be subject to a verbal warning, potentially a written warning, or could it lead to termination of employment? So it is very important that staff are made aware what could be expected of them and what processes they can expect to receive as a result of those actions. But also, it's a mutually beneficial document because there will be information in there for the employees if they, for example, have a grievance and they need to know how to raise their grievance internally. It'll also have the statutory required policies around bullying, harassment and sexual harassment in the workplace. So if any of those situations was to arise for the employee, that they would know exactly how to go about raising that issue or complaint. So what type of policies do I need to have in the business? Well, basically the policies will vary on the type of business that you run, but there are some that every employer should have regardless of their industry. So for example, the disciplinary policies, grievance, bullying, harassment and whistleblowing policies are all required. And equality policy is also really important because it shows your commitment to a level of playing field when it comes to recruitment, promotion, pay, etc., and ensures inclusivity for all of your workforce. It's also important to have policies on sickness, absenteeism, annual leave, flexible working, health and safety, and a COVID vaccine policy are also very useful to communicate to your employees what their rights are and what the expectations are on them. The next slide, I'm just going to show you a brief example of some of the policies that you could see in your employee handbook. You might have your wages and salary policy, wastage policy, mobile phone usage policy, copyright, whistleblowers. So it is very important that you do have this document in place and that it is updated every year, including all the updates in legislation or any change in statutory entitlements that the employee may be entitled to receive. So if we're operating on outdated or old policies, it potentially may become ineffective. So we will need to ensure that we are updating it annually. Just to go through one or two of the policies that we have highlighted here. So a mobile phone policy. This speaks for itself. Obviously, if you have staff that are using their phone on the floor or on the workforce, we need to be able to prohibit their usage of their mobile phone and only during hours of work. Obviously, they can use their mobile phone during their break times, but we want to ensure that they're not using their mobile phone during hours of work, and that needs to be expressed to them in writing. If, for example, you find that you have repeat offenders of employees who are consistently using their mobile phone after being given friendly kind of cautions not to use their phone, you can then take them through disciplinary action, and if needs be, we can go through the disciplinary channel of building up warnings for that employee, starting with your first warning of a verbal warning and continuing through the warning process if it's the case that they haven't prohibited using their phone. So the purpose of the policies really is to allow you to take disciplinary action if there was any breaches of the policies found. So what do you need to do now? All employers need to review their employment documentation to ensure that it aligns with the changes brought about by the regulations. So the first change that's brought about, so you have to review your company policies and practices around the probationary periods. I think the probationary periods is kind of a very big one that people are looking for information around. It was a big change that we saw this year. So with effect from August 2022, the probationary change was introduced and it was brought into the private sector. So no more than 6 months in duration can be applied to a probationary period. Employers may extend the probationary period only on exceptional basis. So for no more than 6 months, subject to a 12-month maximum probationary period for the employee. This means the employers will therefore be in a position to extend probationary periods only if it's an exception rather than customary to extend the probationary periods. It is in the employee's best interest. If the alternative is termination, extending the probationary period is presumably in the employee's interest. The extended probation period lasts no longer than 12 months. And there may be a limited number of employees in the private sector who commenced employment prior to the 16th of December who have signed employment contracts that include a probationary period of more than 6 months. In these circumstances, the probationary period expires 6 months after the contract was signed and not the date on which the longer contractual probationary period would expire. So just to kind of give an example of when it would be acceptable to extend the employee's probationary period if the employee was on long-term absence, for example, and they needed more time. Probationary periods in fixed-term contracts. So under the Protection of Employees Fixed-Term Work Act, as amended by the regulations, where a fixed-term employee has entered into a fixed-term contract with the employer, The length of the probationary period must be proportionate to the expected duration of the fixed term contract. So if the fixed term contract will not be 12 months in duration, 6 months probationary period would not be proportionate. So you would have to reduce the probationary period to ensure it's proportionate to the actual length and duration of the contract. In addition, where the employer proposes to renew a fixed-term contract for the same functions and tasks, the fixed-term contract shall not be subject to a new probationary period. So if the fixed-term contract rolls on, there will not be a second probationary period. A fixed-term contract of 10 months, for example, should not include a 6-month probationary period. We've mentioned that, as the probationary period must be proportionate to the length of the contract. And then finally, we'll have a look at the absences during probationary period. So if an employee is absent from work on any form of statutory leave, for example, it could be maternity leave, parents' leave, statutory sick leave, etc. During the probationary period, employers may extend the probationary period by the length of the employee's absence. So if they're absent for 4 weeks on sick leave, you could extend their probationary period by that 4 weeks. The duration of the employee's absence on statutory leave will not interfere or count towards the 6 months maximum. It's important to note that only absences on statutory leave will allow the employer to extend the probationary period. The regulations don't allow for extensions of the probationary period for absences that are not statute-based. So, for example, unauthorised absences will not be considered statute-based. The second, what do we need to do now? We need to ensure that we review how we are managing any workplace training requirements to ensure that employees are not bearing the costs of any such training. So for this one in particular, we need to ensure where the business is required by law or by collective agreement to provide training to the employee to carry out their work, you must provide such training to the employee free of cost and count the training as working time. For the employer, you must ensure that all mandatory training should be treated as paid working time and take place during the working hours where possible. The next thing we need to consider is how much notice should the employee receive of their working hours and whether they are always working within their stated reference hours. So for this, we need to make sure that we're giving at least 24 hours notice of when they are required to work. Employers must ensure that work assignments take place within the reference hours and days and notify the employee as part of their written terms. If you do not provide an employee with the minimum notice of 24 hours of their next work assignment, or the work assignment is to take place outside of the referenced hours and days provided in writing to the employee, then the employee is entitled to refuse the work assignment without any adverse consequences. So in short, we must provide at least 24 hours notice of the work shift to our employees. If we have not provided 24 hours notice to the employee, they can then refuse to work that particular shift without any adverse consequences being applied. So we can't put any penalties on the employee as a result of turning down the work because it wasn't within the 24-hour period. The next change we need to ensure that we have is that we've reviewed your exclusive services clause to ensure that they are consistent with the new parallel employment rules. So what does this mean? We must not prohibit an employee from taking up employment with a second employer if that second job is outside of the work schedule you have agreed with the employee. You may object, however, if the employee's second job is not feasible based on objective grounds. Those objective grounds could include health and safety reasons. They might be risks to your business confidentiality. They could be risks to your integrity of the public service, or there could be a conflict of interest with your own business. So if this is the case, if you do object to a staff member taking up a second job, you must provide them with details of any such restriction, including the objective grounds in either the contract of employment or in a separate written statement provided to the employee. So it's good to have this provided to the employee in advance of their employment starting, along with their contract of employment. The next thing we need to look at is if you have posted employees working in other EU member states, ensure that they receive the level of information required under the regulations. So where an employee is a posted worker within the meaning of the European Union, Posting of Workers Regulations 2016, additional information must be provided. That information must be the payment of which the employee is entitled to in accordance with the applicable law of the host member state, i.e. Irish law, any allowances specific to the posting, if any, and any arrangements of reimbursing expenditure on travel, board and lodging. A link to the official national website developed by the host member state concerning the posting of workers and the provision of services. So what must the employer need to do? The employer should have a written statement provided to the employees who are required to work outside of the state and must now include the country or countries in which the work outside the state is to be performed in and its duration. Ensure you provide any employees who are posted to the work in other EU member states with all the relevant information. So it's very important that we do follow these regulations because, again, they're not recommendations, they are requirements. Again, we need to prepare to receive requests from existing employees for an updated written statement of terms of employment. That includes all the new terms required under the regulations. So as mentioned previously, we do need to ensure that if there is any updates to their existing terms of conditions, terms of employment, contracts of employment, or even employee handbook, we do need to update those and be prepared for requests from our employees to expect those updated copies. Even if there are no requests for updated copies, it's still important that we update the employee handbook and that we provide the updated employee handbook to our employees so that they're aware of what the changes are as well. Okay, so that concludes the information section. I am going to go through live questions and answer section in a moment, but just for your own notification, if you do have any specific questions that you want answered by an expert, or if you want to receive a confidential follow-up review of the current legislation in place or your own current documents, if you would like your HR policies and health and safety programs that you have in place to be reviewed, a Peninsula consultant will call you in the next 1 to 2 business days and they will book you in for a complimentary one-to-one business review. So this business review will go through everything we've just mentioned there, and if you have any concerns or questions, you can go through with your consultant on the day. Okay, so you sent in your questions previously and I have them here in front of me. I think Sarah is going to read out the questions and I have your pre-prepared answers here.
Yeah, brilliant. Thanks, Lesley. So I'll just run through some of these questions. So the first question that we have is, as a part of the disciplinary process when issuing a verbal warning, does notice have to be given and can the employee bring someone with them?
Yeah, that's a good question. It's a question we get very often here on the advice line, and it's also a question we would get a lot of the times at our seminars that we would conduct. So in short, yes, there would need to be notice provided to the employee. Basically, any potential disciplinary process and the outcome being a warning or some more severe outcome, there needs to be prior notice to the employee. So what that notice needs to look like, you will have to complete an investigation. The investigation needs to determine if further action is to be held, which would be the case of a disciplinary hearing. The disciplinary hearing is where you will give your employee prior notice, so they're entitled to receive this in writing. You should list all the breaches and allegations on this invitation. There needs to be at least 24 hours notice of the meeting. So the more notice you can provide, the better, but the minimum notice you should provide is 24 hours notice. And they do have the right to bring representation to the meeting as well. Obviously, the outcome then is a follow-up of the outcome in writing. So if it is a verbal warning, you will follow up with the employee in writing to ensure that they're aware of what the outcome was.
Brilliant. Okay, I know one of the questions we get a lot as well is, when someone can bring someone with them, can they bring anyone with them? Is it a manager? Is it a colleague? Is it someone specific?
Yeah, so we would always recommend that you bring either, if you are a member of a trade union, that you bring a trade union representative with you. And if you're not a member of a trade union, then you would bring a colleague with you. We would always recommend against bringing family members or potentially legal representation. So you can have it in your employee handbook, your policies, that they're entitled to a colleague or a trade union representative.
Great. Okay, that's cool. Okay, so the next question there is, what is the position of unpaid leave? Is it required legally or discretionally?
Okay, so that's another good question. Unpaid leave outside of the statutory leave. So you will have statutory unpaid leaves that the employees are entitled to. Things like parental leave, if they're parents, they can apply for those types of leaves. But if it's not a statutory leave, if the employee is applying for unpaid leave due to personal preferences, personal reasons, they just want to take time off, then that's not something that's legally required. So the employer can use their own company discretion when deciding if they will agree to the unpaid leave or not. So they will take into consideration, obviously, the impact it will have on the business. Potentially, it might be a particularly busy time of the year for the business. If that's the case, you could potentially postpone it, or you could decline the request entirely. But it will be a discretionary benefit that the company will provide.
Brilliant. Okay. The next one we have here is, does a contract of employment need to contain the number of hours per week?
Okay, perfect. So it does need to contain the number of hours. The short answer is yes, it does need to contain the number of hours. If you have a contract of employment that only states potentially that they'll work Monday to Friday, but it doesn't specify the number of hours, it will then be in breach of the terms and conditions that are provided by the Miscellaneous Provisions Act. So as we saw in the presentation, one of the key terms that we have to include in the first 5 days is the minimum number of hours that the employee could be subject to working in any given week.
Brilliant. Okay. And the next one there is, can a part-timer do full-time hours without changing the contract?
Okay, so technically, yes, they can if they're working the full-time hours in a kind of a short-term position. If you have an employee that's working full-time hours on an ongoing basis, that employee could apply for what we call a banded hours contract. So a banded hours contract entitles the employee to assess the average hours that they've worked. And if the average hours they've worked is full-time hours, then they are banded to that hours contract for the coming 12 months. So if you want to ensure the employees remain on a part-time contract, you can just have them working full-time hours on a very short-term basis. So for example, if they need to cover annual leave or if they're covering sick leave. But if they're working full-time hours on a continual ongoing basis, then they potentially could apply for banded hours contracts, which will lock them into the full-time hours for the coming 12 months.
Fantastic. Okay. We have another question here, which is, how do you enforce taking holidays when employees refuse to take them? I know we get this one a lot. I always see it come through in the questions.
Yeah, definitely. Sometimes employees, they're just happy to work on, they don't really want to take their hours, they build them up and potentially want to use them in a later date. Well, in this instance, it's really not going to work too good for the business if we have a lot of holiday hours built up. So we want to ensure our employees are using them. Number one, because of health and safety reasons. Number two, it's part of the Organisation Working Time Act. Employees are entitled to take their time and they should take their paid time off. So to answer the question, we can have a policy in our handbook. We can enforce where we assign holiday hours out. So basically, the best practice would be approach the employee, inform them that they have XY numbers of hours built up, that you would like them to submit their desired weeks or desired time off within 7 days. If in 7 days they haven't submitted those required times off that you've requested, notify them in writing with 30 days notice that the allocated times have been assigned to them. And if they haven't come back with their own hours, then you will assign them out. And you can consistently assign out the hours as long as you're providing 30 days notice in writing.
Brilliant. Okay. Right, and then we also have another question regarding holidays. So what are part-time employees' bank holiday entitlements?
Okay, so this is a question I think confuses a lot of people. I think working out the bank holiday entitlements can be a tricky one because full-time employees seems to be straightforward, but then the part-time employees seems to cause some confusion. So basically their entitlements, number one, depends on their schedule, and number two depends on the hours that they've worked. So to be entitled to receive the bank holiday payment, they do have to have worked 40 hours in the previous 5 weeks leading up to that specific bank holiday payment. And if they're scheduled to work on that bank holiday, then they're entitled to an additional day's pay. If they're not scheduled to work on the bank holiday, then they're entitled to 1/5 of their normal weekly pay, and then that will be paid to them the same week of the bank holiday. So they are entitled to payment. They're entitled to either a day's pay if they've worked it, or 1/5 of their normal weekly pay if they haven't worked it.
Brilliant. Okay. And we've got another question here, just a final question. I know you did cover this, but is the right to request remote working legal yet?
Okay, so we did mention this already in the webinar. It's not introduced yet. So as we mentioned, it is potentially coming in by the end of autumn. It hasn't been set as a date yet. That could again be pushed out towards the end of winter. We're not certain, but also it could be brought forward to the end of summer. So we're just going to keep an eye on the updates. And when we have the information, we are going to post that out for everyone to be aware that the flexible working, remote working has been introduced. But to answer your question, at the moment, no, it's not in place yet. Do we have any other questions?
You know, you do have one that's come in here, which I thought might be of interest to you. You might want to answer just. So it's from the audience here. That was a live question because I can see there are a few coming in. However, I'm very cautious of the time, so I'll just do the one if it's okay.
That's fine.
So the question is the employee handbook mandatory?
Okay, so there are policies in the employee handbook that are mandatory. So you do have statutory policies, for example, bullying, harassment, sexual harassment, harassment in the workplace. We must provide those policies to our employees, and that has to be made available. But the other policies contained within, they are not mandatory, but they are highly recommended because they will support your operations of your business, and they will support your disciplinary processes and all the other processes that we've mentioned throughout the webinar. So it's not mandatory to have the full employee handbook, but there are certain policies that are statutory mandatory. So you do have to have those included for your employees.
Perfect, fantastic. So I guess, you know, that I'm aware of the time there, so we may finish up there if that's okay. Any questions that weren't answered, we can definitely get someone to contact you directly.
Yeah, that's perfect. I'm going to move on though for the next slide.
Mm-hmm.
If you want to introduce this slide, Sarah.
Yeah, so I thought I would just let you all know. So if you enjoyed this webinar today, and we do have a number of webinars coming up, I've just listed the next two coming up there. So we have on the 20th of July, the dark side of HR. So that's going to be covering workplace bullying and harassment. So it's just, again, it's the same time. It's 2 to 2:45, so 45-minute session, and it will go through, you know, the must-knows for handling bullying and harassment in your workplace. Then on the 2nd of August, we are doing a HR questions clinic, if you will. So it's Asking an Expert that's hosted by our colleague Emma Hickey. She will be covering any questions that you submit and just going through kind of top tips for workplace HR. I'm going to put in the registration links in the chat box. So if anyone did want to register, you can just click the links and you should be able to join. Okay.
Great, thanks, Sarah. Yeah, so that's the end of our slideshow, guys. Thanks everyone for attending today. And again, any questions that weren't answered, we'll try to get back to you.
Brilliant. Thanks, Lesley.
Thanks, guys.